Kushi, your host, extend a warm welcome to this session. But before getting on board with the event, I want to inform you all that we have organized this event under IIC, that is Institutions Innovation Council, was established on 21st November 2018 at JIMSVK. Since inspection of IIC by the Innovation Cell, as per the norms and directives of Ministry of Education, then Ministry of Human Resource Development, it is established to engage large number of faculty, students and staff in various innovation and entrepreneurship related activities such as hackathons, leadership talks, ideation, workshops, seminars in IPR, entrepreneurship and other competitive events to enhance the innovation and entrepreneurship ecosystem in the institute. Now, I would like to introduce our esteemed speaker for the day, Mr. Siddharth Sharma. Siddharth sir is a highly accomplished professional in the field of intellectual property rights with over 11 years of experience. He is an engineer in electronics and telecommunication field, a qualified patent agent and an advocate, making him an expert in the technical and legal aspects of IPR. Siddharth sir's extensive experience includes drafting and filling of new patent applications in India and abroad, procuring applications, attending hearings before the controllers at the India Patent Office, and conducting IPR training sessions. He has a proven track record of successfully managing complex patent portfolios for clients across various industries, including technology, electronics, telecommunications, and software. Siddharth sir brings a depth of knowledge and expertise to the table, making him an invaluable resource in the realm of intellectual property rights for startups. Today, he will enlighten us on the topic of intellectual property rights and IP management for startups. Let's express our gratitude for Mr. Siddharth Sharma's presence and his valuable insights. I request Disha to come here for felicitating our guest with a plant. And now, without further delay, let's warmly welcome Siddharth sir as he takes the stage.
Good afternoon, everyone. I hope I am audible to everybody, including students at the back.
Yes, sir.
Right, perfect. Thank you. First of all, Kushi, right? Thank you for the introduction. And it's an honor to be here at this esteemed institute and to be presenting this session on intellectual property rights for all of you. So before I begin, I would like to ask how many of you are aware of intellectual property rights, or even like remotely 10%, 20%? Any idea? Anybody? A little bit? Yes? Right. Okay. My next question is, how many of you have seen Shark Tank these days, right? A lot of you, right? So often you might be hearing concepts like, are you guys holding patents for the technology, or are you guys holding any intellectual property for the whatever product they are displaying at during the episode, right? So today we are going to learn a bit more about the concepts of intellectual property rights, and these are entirely different from your regular property rights, so please don't be confused about any of it. So without taking any further time, I'll just dive into the topic for today. Before that, just a quick introduction about our firm. Ours is one of the leading IT firms in India. We have a total strength of over 190 personnel spread across the offices in New Delhi, Gurgaon, and latest being in Mumbai. Our firm is led by Mr. Rahul Chaudhary, who is one of the esteemed litigators in India. And we have the honor of serving more than 100 Fortune 500 companies and representing their interest in intellectual property rights space. And our experience, overall experience in the field of IP goes back 4 decades. So our firm was established in 1983. And in 2023, we completed our 40 years. Yeah, sure. All right, sure. Better now, I think. Okay. All right. So today we'll be looking at what intellectual property is and why should you protect an idea, what are the different types of intellectual properties, and within the realm of intellectual property, what exactly patents are, and if any one of you eventually goes down the line of starting their own startup, why IP would be important for you, and what investors eventually look for when you have a startup and you have an IP for your startup as well. So to begin with, let's take the example of this bottle, right? This bottle has multiple facets of IP in this. So when I say that, what do I mean, right? So let's say the deviser of this bottle, Aquafina bottle, somebody must have designed this product. Somebody must have come up with the name of the product label, that is Aquafina. Somebody must have come up with the tagline. Let's say Tata Sky ka tagline was isko laga dala to life jeena lala. So all those taglines, all these creations of human mind, this speaker set, this laptop, this chair, the projector, everything is devised by human beings. And we have come a far way from inventing the wheel to inventing nearly all the electronic vehicles in today's day. So all these creations of human mind, whether they are in the form of products, whether they are in the form of paintings, whether they are in the form of songs, whether they are in the form of apparatuses like chairs, desks, tables, etc. Everything that you create out of your own ingenuity, your own mind, without copying others, you can take IP protection for this. So what I mean by that is that if I design this chair, nobody can freely come and copy this chair if I have the intellectual property rights for this chair. Likewise, if I have designed this bottle, nobody can come up and freely produce this bottle and sell it in the market without first taking the licensing rights from me, right? So likewise, it is important, like the design of this sofa cushion cover, anything artistic or anything machine based or anything that you produce out of your own mind is your intellectual creation. And once you create anything new, you can apply to the government for procuring the rights and getting the rights. After you get the rights, you can stop others from freely copying your inventions and your creations, right? So they come in several forms. Number one being patents. I belong to the patents fraternity, being an engineer. So anything of technical nature that you innovate, let's say this projector is there, and there are projectors out there in the market which help you autofocus, auto align, etc., etc. All these are innovations. So when I come up with these innovations, I wouldn't want anybody to come and freely copy them. I would want to get certain licensing and certain royalty deals out of that. So I want to make money. I think everybody wants to make money at the end of the day. Likewise, all the shoes of Puma, Nike, they have those swoosh signs, right? So all of us are able to recognize a product by their symbols, their logos. So all these symbols and logos and the catchphrases that come along with the products, basically anything which straight away help you relate to the product. So any box you see and you see that Nike ka swoosh sign on it, you'll be right away able to recognize, okay, this tick mark means Nike product, right? Likewise, even a panther on a box would tell that it's a Puma product. So such things are classified under trademarks. Moving on to the designs of these stools, these chairs, they happen to fall under the registered designs category of IP. And likewise, any song that I write or any painting that I create will fall under the copyright protection. So why you need to protect the idea? First of all, I can create 1,000 things and I can go on shouting around in the market that I created X, Y, Z, but nobody would believe me until and unless you have a government certified stamp to it, right? Even in the case of actual properties, when you own a house or a building, you have to have some form of certificate or land papers to it. So likewise, if I devise this bottle and I come to you as that, you need to stop manufacturing this without taking license from me because I created this, you will say, ki, by what authority am I telling you? But after I have the IP rights. So it's a form of recognition for the inventor or creator of things, that I'll show to you guys that I have a design certificate from the patent office, and the government has authorized me and given me the rights to not allow anybody to freely copy my designs, and therefore you guys either need to stop the production of your products, or you be happily paying me 1 rupee per bottle, and then you can manufacture as much as you want, right? Secondly, besides me being a bottle manufacturer, packaging it, selling water, I being able to license you, it creates an additional revenue stream, right? Thirdly, it introduces a competitive edge in the market, because people would like to collaborate with me, knowing that I hold the exclusive right to any creation that I have done. So you guys knowing that a Puma product sells better, right? So anything you design, let's say the Crocs that are there, right? Crocs have those steps in which you can put in artistic figures and whatnot, right? So you would like to collaborate with Crocs because of their competitive edge that they are holding for their product, right? And again, when you go for investment rounds and etc. in future for your startups, so it also, as you have seen in Shark Tank, that the evaluation of a company is taken much more seriously once you know that you have the IP protection for your business and your vertical, because then nobody else can freely come and copy your business or freely come and copy your products. So just to give you an example, every one of us have had Coke or Pepsi in the can product, right? So there is a ring pull tab on this one, and whenever you wish to have it, you need to pull it out, and then you go about happily drinking the beverage. How it started was that Aramil Fraze had one time gone on a picnic with his family, and this is way back somewhere in 1960s, etc. He had gone and he had forgotten to take a can opener with him. So ultimately he ended up making a quick fix by hitting it against the car bumper and etc. and then opening the can and then having the beverage. But he came back to his workshop, and then he got down to thinking of a solution to such episodes where you forget the can opener, and why there is a need to separately carry the can opener when you can devise something which of an arrangement which can help you open the can there and then itself. So he came up with the idea of a ring pull tab design, and then he licensed it to Coca-Cola at 1/10 the penny per can for his invention. He devised this ring pull can system, he got a patent for it, and then he licensed it to Coca-Cola. And during the pendency of the exclusive intellectual property that he created, he earned close to 1,50,000 UK pounds per day from the licensing entities. So that is the kind of money that can get involved in certain products which you create out of your IP. So that is something which helps make IP very essential. Even Apple in today's date, they have a sitting license agreement with a startup company in Pune who devised the antenna design, which is in some form used in Apple phones. So again, it was a multi-million-dollar deal, all because the Pune company was able to figure out the basic problems with antenna, their positioning in the mobile device. Like, I'm not sure how aware you guys are about this, but back in the day, there came an article, I think somewhere around the release of iPhone 10 or 11. Whenever you used, it was facing a problem that when you hold the phone when you're on call, your hands are actually interrupting the antenna of the call. So therefore, the call signal and etc. were not going out smoothly. But all this was subsequently fixed by virtue of antenna designs, which was created by engineers and licensed to Apple's, which was again a multi-million-dollar deal. So IP in itself has a lot of potential for business, for growth, and of course for revenue streams by way of licensing. So just to give you an example of a company and the various forms of IP that it can carry, Apple, for instance, the half-bitten logo for Apple is its registered trademark. So anything which has an Apple symbol to it with a half-bitten Apple mark you'll be right away able to identify the company or the product behind or associated with this logo. So logos, etc., or the phrase line, or let's say even the Gyani's ice cream that you eat, they are having two different colors. One is blue in color and one is red in color. So why it changed was that originally it was of one color, but the family's son inherited the legacy and then they had a dispute. So just to settle that, they retained the same name, Gyani's ice cream, but they bifurcated their businesses by way of blue and red colorings and all. So that is the power of a logo, and it speaks of your symbol. Everybody is able to recognize Haldiram's or Bikaner Wala straight away from their branding on the package. So it gives you a certain level of confidence as well of what you are buying. So again, the confidence that you're buying a Nike shoe is given to you by the symbol of it. So that is where the symbol becomes very essential and very important. Likewise, patents, it's slightly a techno-legal document. Whatever you create or whatever you advancement you bring into products, let's say I devise this projector with improved aspect ratio, improved display. So all of this, I would need to document it, go to the government, file it with the government and get a patent for it. So this is how something, a patent looks like. It's a legal document. Likewise, designs. The design of a Apple iPhone, the iPods, the tablet, the MacBook Air, etc. Everything designed by Apple is separately protected under their IP. At the end, speaking of copyright protection, so a website of Apple which showcases their content and the product descriptions that they have written on that website happens to fall under the realm of copyright protection of IP. So now coming to the patents part of it. So what exactly is a patent? Patent is something which, as I previously explained, that I simply can create things, but for me to be able to stop everybody from freely copying my product, I need to secure a document from the government, and that document is known as a patent. But why will the government give me the document? The patent concept works on this fundamental thing that, let's say I have made an improved coffee machine, right? My regular coffee machine, it has a storage of for the coffee beans, and then I press the buttons and it gives me the coffee. But what if I want a particular strength of coffee? I devise a coffee machine in which I have a storage bin which has a technology that it can bifurcate the coffee beans by its weight and by its dimensions, right? So that is something advanced that I have created. Now I would want that nobody can freely copy it. So I'll go to the government patent office, I'll tell them, I'll prepare the document that I showed you guys earlier. I'll give it to the patent office. The patent office will take the document, they'll do their own research, they'll do their own due diligence, whether the coffee machine was new or not, whether Starbucks was previously using it or not, or anywhere in the world, if anybody was using it or not. So if they come to the conclusion that, okay, nobody was using it, and he has actually created for the first time a coffee machine with coffee bean holders of a specific type, so I can be granted patent protection, right? And the tenure for patent protection is for 20 years. Now imagine the kind of money that guy must have made for that ring pull tank case. Likewise, the government will give me protection for 20 years, and for 20-year period, I would enjoy the exclusive rights to stop everybody from making it until and unless they come and take a license from you. So that's the fundamental of patents. It's a monopoly right which lasts up to 20 years, and in return for this exclusive right, I need to tell the government that what exactly my machine is, how I made that machine, what are the dimensions of that machine, and how anybody from the coffee industry in tomorrow's date can make that machine. So that once my period of 20 years it lapses, then everybody can freely come and use the technology. So one of the fundamental and ultimate goal of patents is also to bring advancement into the society. So hence, to encourage me as an inventor to not simply create something new and use it secretively, but to come out in the open and give it to the society, the patent system was created wherein the government gives me exclusive right, okay, for a period of 20 years, you enjoy the money, you enjoy the monopoly, you license it to people as per your terms and condition, but afterwards it's free for use for everybody. I think everybody must have shopped on Amazon.com, right? So Amazon there is this feature where this one click to pay feature is there. Now of course it has evolved in the past 10 years, but going back 10 years, Amazon had this single click to pay feature wherein the card details of your account were stored against your user ID, and any product that you kept in your cart, you were simply able to buy it by clicking on that one click button. So that one click button payment process was patented, and I think its patent somewhere lapsed around 2016 or 2017, and now it is free to use for everybody. But prior to that, everyone wanting to implement that one click to pay system had to pay some royalty to the Amazon company. Likewise, I think the happy birthday song that we all sing very happily to our friends was actually copyright protected, and its copyright also ended somewhere in the 2020s. So a lot of IPs around us, just that we need to be aware of actual things. So this all I have explained to you, that once I create something new, there has to be a paperwork in which I write out whatever new that I have created. I go to the patent office, I give it to them, they do their own due diligence. If it is found that whatever I have created is actually something new, they give me the IP rights for this thing, and if it is not new, then they can very well reject my application as well. So now comes the part who can file for a patent application. So anybody who has created, me in my individual capacity, I can go and file for a patent. I can go and file for a design protection for this bottle if I have created this bottle. But imagine a scenario where I am working for a multinational company like Apple, or I am working for a multinational company like Samsung. Then often in such instances, there are arrangements between me and the company that because I am working for them, I am using their resources. So whatever I will create using their resources will naturally be under their ownership. So in such cases, the enterprises will be able to file for a patent application. And likewise, in the case of demise of an inventor of a technology, their legal representatives can also file for patent protection. So now, when I say that I have created the coffee machine, right? The patent office will not come to me with open arms, so like, here's the garland, you have created such a new thing. They will inspect my patent technology on couple of aspects. They will check whether it is new, they will check whether it is inventive, and number 3, they will check whether it has industrial capability or not. Now what we mean by these concepts, we'll just take some examples of these concepts. Novelty is something that I say that, okay, I have made this bottle, but everybody knew that this bottle is being sold in the market for the last 10 years, 15 years. So my claim that I was the first one to make this bottle is thrown out of the window, because this bottle is being sold in India for like 15, 20 years. So patent office will go and check, okay, he has built this bottle, but was the bottle being sold previously in India? Was it being sold anywhere in the world? And if they come to a conclusion that, okay, the technology that he is claiming that he has made was already known to everybody in public, then in that case, it will be determined that my patent lacks novelty. Just to give you a quick example, all of us exchange data between our mobile devices and our mobile device or a laptop, right? Let us say I create a technology where you switch on the Wi-Fi of two mobile phones and to quickly connect them without any password or anything. Let us say you just need to create a gesture in the air. If I switch on my mobile Wi-Fi, I create M in the air with my mobile, and a nearby device also switches on the Wi-Fi and creates M in the air. So I create the technology that the phone is able to detect the nearby movements and therefore able to connect. So if I go with this technology to the patent office will search for it. If they don't find anybody proposing or practicing similar technology, then they will be determining that I have novelty in my phone. Next comes the concept of inventive step. Inventive step basically means that, okay, I have created a solution to a problem, but was this very obvious to a person who's from that same technical field? Let's say if I have to use my mobile phone to switch on and switch off the lights of this room. So I think most of you will be able to guess that all I want or all I require for achieving this is that I need to simply install a Wi-Fi module in the switching plate which is there. So therefore I can connect. Likewise, the Philips has a lot of LEDs coming out in the market which you can control. The lights you can switch on and off. You can even change the color of those lights. So what has basically helped your mobile device to connect with the Philips light is basically the Wi-Fi module which is now coming in, integrated into the Philips bulb. So all of this is very known things, something which anybody could think of. So this concept is known as obviousness. So patent office will see, okay, nobody was doing it earlier, fair and fine, but was it obvious to a person skilled in the art? Could the person have done this thing without any extra inventive skill? So just to give you an example, same invention in which Wi-Fi connectivity is happening, but now this time the patent office is able to look for a document which was having this technical disclosure which talked about gesture-based connections between devices. All I did was I added the Wi-Fi element to this thing. So because of this small association between two technologies which were sitting in the market previously, patent office will very well conclude that whatever I have created is not new. It is simply combining two sitting technologies. So therefore, now in this case, my patent would be known to be lacking inventive step. So our three pivotal points that it should be novel, it should have inventive merits, and it should be industrially applicable. So the inventive merit aspect will be lacking in my patent. Just to give you some funny examples of how the inventive merits were found to be lacking in some of the cases. I think everybody would be knowing Donald Duck or would have heard about him, right? So back in the day, there was this situation in Kuwait that there was a freighter ship right at the harbor of Kuwait carrying like 55,000 sheep and all. And when they were deboarding the sheep, some decapitalization happened and the boat started sinking. Now the thing was that if the ship would have sunken all the way, the sheep would have died, they would have contaminated the water, and the drinking water of the city would have affected, and it would have taken a large number of days to clear everything out, right? So to be able to solve this problem, the requirement was you had to keep the freighter ship afloat. The ship was sinking. There was a Dutch inventor who came up with the idea of putting in plastic balls within the container to keep it afloat. A total of 27 million plastic bottles or balls were put into the ship so as to keep it afloat. And the idea worked as well. And later on, the inventor went to the patent office that I want a patent protection for the concept that if you want to keep things afloat, you can put in the air-filled entities or boxes into the container and it will stay afloat. But the patent office examiner who was examining the application, he found something of similar nature proposed previously in a Donald Duck cartoon book, in which a yacht was sinking or had sunken to the lake bottom, and Donald Duck had come up with this idea of placing a pipe and putting in the air-filled balls in the yacht so as to bring it to the surface. So because the concept was known previously prior to the inventor's claim, so therefore the patent was not granted to this particular inventor. Likewise, Dennis the Menace, again, I think people would have heard back in the day. So in one of the cases, one UK-based inventor had come up with a doorbell system for pets, where they had placed at the bottom of the doorway a bell system which a pet could come in happily and like press, and then the owner would get aware that okay, the dog is now wanting to come in or the cat is now wanting to come in. Now in this instance, the patent examiner which was examining this application, he was able to find the prior art sitting in his home at the dining table because his daughter was reading a comic book, the front page of which had the similar concept disclosed as shown in the image. The image on the right shows that a dog was pressing the doorbell, which was located very near to the bottom side of the doorway. So such concepts, when they are found available in the market, the patent office has every right to refuse the patent application. So the bottom line being that you cannot claim to be your invention or your creation if it is already out in the market and you are just combining two different pieces of technology together. Likewise, there are certain exclusions. You can't patent everything which you create. For example, a method of medical treatment, let's say a method of treating skin burns, you can't claim monopoly over that because that is eventually against public morality in some sense. Likewise, if you happen to somehow discover some law of nature and law of gravity, let's say, was discovered by me, I can't go and claim exclusive use of gravity for myself. I can't stop the whole people from using gravity because it exists in nature. That is not something which I have created, right? Likewise, computer programs, etc. You cannot claim a patent for it. You can go for a copyright protection for it. Similarly, atomic energy or presentation of information, patent protection is not available for such kind of technologies. Now comes the part where why IPR would be important for you guys or important for people who are having startups or aim to have a startup. I think everybody, most of you must have seen the movie Social Network on Netflix, where the concept of the creation of Facebook was shown and how it came into being. And there was a famous dispute regarding the creation of Facebook, that how it wasn't Mark Zuckerberg, but he heard the idea from the Winklevoss brothers, and a legal dispute was shown in the movie. So that was based on reality, and eventually there was some 60 million pound settlement between Mark Zuckerberg and the brothers. Likewise, there is a series called The Playlist. It's based on the creation of Spotify and how Spotify came into being, and the copyright laws relating to Spotify, and how the due diligence of the lawyers of Spotify at a very early stage, probably within the first 6 months of creation of Spotify, helped them getting big contracts and big music contracts later down their journey. Again, a third series is The $1 Billion Code, which is relating to Google Maps, and it's airing on Netflix. It also talks about how the technology was first proposed to a big enterprise and how that enterprise ended up using the technology and what were the downfalls and pitfalls of these technology. So just to sum it up, once you have IP protection and IP for your startups, for your businesses, etc., it comes with several advantages. First of all, being that it helps add a revenue stream in the form of sale of your invention, sale of your products, and licensing of your products. It helps avoiding competition from freely copying your creations, and it helps protect your R&D efforts today we are looking at bottles and chairs and everything which can be produced in like say months or years time frame or time period. But imagine the essential drugs relating to cancer, etc. So these these drugs, they have many years of R&D efforts behind them, probably close to 5 to 10 years of R&D efforts. So a company investing so much time in these medicines would definitely want the return on these R&D efforts as well. So nobody would be motivated to just spend 10 years in discovering a medicine just to allow everybody to freely then copy it in the market. So therefore, in such instances, IP rights become of much more greater importance. And as I previously mentioned, that it is also, it gives you a major advantage from investor perspective, because investors tend to appreciate products which have sitting IP in this. Like I say, a lot of you might be seeing Instagram ads of new sneakers called Comet and whatnot, right? Comet in today's date, it's like everywhere, but they are able to build a brand because they have also identified the logo of their brand. They have done the copyright for their website. They have design patents for this, the way their shoes are looking, the way their slides are looking in today's date. So that is one company who's very diligently ensuring that all IP aspects of their business are heavily protected. Likewise, I think there was one episode in which somebody with a cycle and a EV battery association to the cycle had come up in Shark Tank, but that guy has also applied for a patent protection, that how to convert any normal bicycle into a battery-driven bicycle. So one of the episodes also featured that, and that person also had a patent protection for that concept. So essentially, if you are diligent enough, if you're carrying an IP acumen right from the word go, so you wouldn't end up in situations like Mark Zuckerberg versus the Winklevoss brothers. You would have your protection streamlined and figured right from the word go. And by doing this, you will be able to secure better monetary and licensing stream down the line. So that was a brief primer on intellectual property. The actual one is like for months.
Thank you, sir, for your words of wisdom. I would like to thank you for such an informative and intellectual session. We are having the Anisha Tandon ma'am amongst us.
Thank you very much, Khushi. Thank you, Siddharth sir, for coming and enlightening us about the IPR and IP management for startup. And it was really an interactive and informative session. And hope our students enjoyed and learned a lot about the IPR, the patents. So thank you very much. Thank you.